In the following, I would like to discuss with you how applicants can be represented in international applications. There are actually two forms of representation under the PCT. There are agents and there are common representatives, and I would like to discuss that with you in some more detail. We also would like to discuss what the situation would be if no representative has been appointed. And then I would like to talk about how representatives can be appointed and the legal effects of any acts taken by such a representative. So, as I said, there are two forms of representation in the PCT. You can either appoint an agent or a common representative. The essential difference between the two is that a common representative has to be one of the applicants. He needs to be listed in the request form as one of the applicants. Only then can you appoint him as a common representative. An agent, on the other hand, is a third party, a professional that you can appoint to represent you for the purposes of your PCT application. So those are the patent agents and patent attorneys of the world. Now, let's think about who can actually be an agent. Now, this is essentially governed by the national law of the receiving office with which you file your particular international application. So, if the national law allows someone to be a representative before that particular office, he is also entitled to act as a PCT agent for particular international applications. And once someone is entitled to act before a receiving office, he is equally entitled to act before any other international authorities. So that's the searching authority. If you file a demand under Chapter 2, it's also the International Preliminary Examining Authority, and of course it's also the International Bureau here in Geneva, Switzerland. Most applicants will simply appoint one agent that will be in charge for the entire international phase of their international application. However, there are some applicants who might wish to choose to appoint an agent for just specific parts of the international phase, namely the search part and the international preliminary examination part. This is possible, but in this case, if you want to appoint someone, let's say, just before the procedure of the IPA, this agent needs to be entitled to act before that particular IPA. So let's take an example. You have a US filed PCT application with our US. In the US, you can choose between various international searching authorities. So for instance, you could also choose the European Patent Office to do the international search for this application. So if the applicant decides to do that, he can appoint a US agent who's entitled to practice before the USPTO, and that agent is immediately also entitled to represent the applicant before the EPO as International Preliminary Examining Authority. However, some applicants might wish to hire a specific agent for the Chapter 2 procedure, and in this case, they would have to hire someone who's entitled to act before the IPA, in our example, the European office, so it would have to be an agent who is qualified to practice before the European Patent Office. It's not a must, of course, to appoint someone specifically for the Chapter 2 procedure, it's just an option. The PCT also provides for the possibility that a main agent can appoint what we call sub-agents. What the PCT actually says is, unless the applicant has excluded that possibility in the appointment of the main agent is free to appoint a sub-agent and delegate some of the work to a sub-agent. Now, let's turn to the question of common representatives. And here the question is, who can be appointed as a common representative? And there, it's essentially, it has to be one of the applicants listed in the PCT application, and that applicant needs to be a national or a resident of at least one of the PCT contracting states. Do note that if you appoint one of the applicants as common representative, you could indicate a different address for that particular common representative other than the address that you used when you indicated that person as an applicant. That would be also permissible. And so what is the situation now if an applicant or a group of applicants chooses not to appoint any representative? Well, first of all, if there's only one applicant, it's not an issue at all. Then of course, that is the single applicant that will receive the correspondence and then that can communicate with the various PCT authorities. However, what is the situation if there are multiple applicants? Well, in this case, we, the International Bureau, but also the other PCT authorities, need one person with whom they can communicate. We don't want to send our notifications to 3 different applicants. We just want to send them to one applicant. And on the other hand, we also need to know which of those 3 applicants in my example would be entitled to come to us and, let's say, correct a priority claim. It can be that all 3 could come to us separately and possibly tell us something different. That would create quite some confusion. So what we need in this case is to single out a particular applicant that we can communicate with and that can communicate with us. And this is the applicant that we call the deemed common representative. And that is always the first listed applicant in a PCT application who is entitled to file that application with the particular receiving office. Let's take an example. Let's say we have a US applicant, a European applicant, and a Japanese applicant. And they're listed in this order in the PCT application. If this application is filed with the USPTO as receiving office, the first listed applicant is the US applicant, so he would be considered the deemed common representative. If, however, this application were to be filed because of the second applicant with the European Patent Office, then the European applicant would be the deemed common representative, even though he's not listed first in the request form, but he's the first one entitled to file a PCT application with the European Patent Office. So I hope you see how this works. Now, a last item here I want to point out: if you did not appoint an agent or common representative, you also have the option in the request form to indicate a special address for correspondence. Now, be very clear about that this is not a form of representation. It's basically just a mailbox. So all our correspondence will be sent to that particular address for correspondence, but the person receiving the mail at that mailbox is not entitled per se to represent the applicants. So really, it's not something that we recommend to most applicants. It's probably easier and more straightforward to either appoint an agent or a common representative, but there might be some special situations where you wish to indicate a special address for correspondence. How are agents appointed, or how are common representatives appointed? Now, the easiest way to do that would be in the request form, or if you file a demand under Chapter 2, in the demand form. So you indicate the agent, let's say, in the request form, and you have your applicant sign the request form. Then the request form itself serves as a power and an appointment of the agent. Of course, the whole thing could also be done by indicating the agent in the request form. The agent signs the request form, and then he submits powers of attorney signed by all of the applicants. Do note, however, in this respect, that most receiving offices have now adopted what we call a waiver of the requirement that powers of attorney have to be furnished. In this case, the attorney signs and would not have to submit any powers of attorney, and he would still be considered validly appointed by the applicants. Now, in terms of powers of attorney, there's either a separate power of attorney, which means it's a power of attorney specific to an international application, or what we call a general power of attorney. A general power of attorney means it's an appointment of a particular agent for all future PCT applications filed in the name of the applicant who signs the power of attorney. In such a case, you would have to deposit the original of this general power of attorney with the receiving office with which you plan to file your future PCT applications with. Now again here, if you file your PCT application, you would have in principle to submit a simple copy of that general power of attorney, but most offices have waived that requirement, so usually you don't have to furnish that simple copy of that power, of that general power of attorney either. It's always possible for an agent to be revoked. So if the applicant does not wish to continue working together with that particular agent, he can revoke the appointment. And if the agent is not happy with his client, maybe he doesn't get paid, etc., he can also renounce his appointment. Now, if an agent or a common representative have been appointed, how does it now work with any acts taken by that representative? Well, in principle, the PCT simply specifies and says any act by an agent or a common representative has immediate effect on all of the applicants. So you really need to be careful who you choose as your representative, because all of their acts, including their mistakes, will be directly attributed to you as the applicant. Keep in mind, though, if a deemed common representative, so a representative who has not been expressly appointed by the applicants, if that deemed common representative tries to effect a notice of withdrawal, he cannot do that on his own. He would need to get the approval and signatures of his co-applicants. That's just a safeguard because he hasn't really been appointed expressly. Also, if an agent was appointed but no powers of attorney were furnished at the time of filing because the RO waived the requirement to furnish powers of attorney. Also in this case, if that agent now submits a notice of withdrawal, he first needs to also submit powers of attorney signed by all of the applicants before he can effect any kind of withdrawal of the international application or of, let's say, a priority claim. So in conclusion, I try to show you that there are really essentially two forms of representation in the PCT. You can appoint an agent or a common representative. And I did point out there is also the possibility to indicate a special address for correspondence if you did not appoint an agent or common representative, but it's not really a form of representation. I explained to you the concept of the deemed common representative, and I also highlighted that a lot of receiving offices have waived the requirement that powers of attorney need to be furnished.